And that leads up to our discussion of the Nosal case. So the Nosal case is a very well-known case. It worked its way up through the courts up into the Ninth Circuit. It was a very highly anticipated decision for a number of reasons. One of the reasons I'll talk about in a moment was that it involved, in the Ninth Circuit, involved Judge Kozinski, who is a well-known federal appellate judge in the area of internet and computer law. Another reason is because of its kind of factual setting and the fact that it did involve another kind of employment sort of dispute. And, here the issue was the defendant had worked at Korn Ferry, which is a very well-known executive recruiting firm, and the defendant went to establish his own business. Now, the defendant actually was a very high-level executive at Korn Ferry. So as he leaves this business, he has former colleagues at Korn Ferry who he's still friendly with, presumably who he may be recruiting to come work with him, send him confidential information. These employees are still employees of Korn Ferry. They have not quit yet. They have not been terminated yet. And they are entitled to access this information. It's confidential, but they're entitled to use it. It's part of their job to have information on people whom they've worked with, on potential contacts, inside industry information that only they would have in this very competitive executive recruiting business. But there is a company policy which prohibits them from giving this information to any outside person. Now, as you might suspect, if you've worked in the industry, I'm sure you know this, but if you haven't, as you might suspect, these kind of policies are very common. I mean, any company of any kind of size or consequence, certainly any law firm you might work for, is going to prohibit you from taking confidential information of the company and bringing it to a competitor. Now, there are going to be limits on this. Again, to what extent this kind of policy is enforceable. It could as a policy document comprise part of your employment agreement with your employer. That agreement is only going to be enforceable to the extent it's sort of consistent with law and public policy and is reasonable. I mean, as a lawyer, even under the sort of rules of professional conduct, there are some pretty significant limits on what a law firm can do if a client chooses to go with you. The client basically owns the file in a sense. You have confidential information of a client, you leave and go to another law firm, the client chooses to go with you, then you pretty much have to have access to that file. But there might be other things, financials, other things like that you wouldn't have access to. And certainly in any other kind of company, any other kind of business, there are going to be restrictions on giving confidential information for things other than the purposes of the business. Certainly giving it to a competitor, you can see how that could be a real problem. So the question is, well, okay, maybe this is some kind of contractual employment claim, but is it a CFAA claim? Is a violation of a computer access policy and access in excess of authorization to the company computer network? And Judge Kozinski decides this. He looks, again, it's sort of an exercise in statutory interpretation, but I think you can see Judge Kozinski's view of statutory interpretation here, which is very much, again, looking at the impact that one interpretation as opposed to another might have on the individual. And so he looks at the definition and he says, if the government's interpretation were right, and you should notice something about this case too, this is a criminal prosecution. This is not a civil case. This is a criminal prosecution. And that seems kind of extraordinary. And in a sense, it is kind of extraordinary. And Kozinski says, look, if the government's interpretation were right, the Computer Fraud and Abuse Act would be transformed from what he describes as an anti-hacking statute into a very expansive criminal misappropriation statute. In Kozinski's view, without authorization applies to outside hackers, and in excess of authorization applies to inside hackers. But his focus is, in using the word hackers, that it's some kind of code-based activity. It's not a policy-based activity violating some company policy, but it's using code, malware, other kinds of exploits like that to get into a system. That's the way he wants to read it. Here, by the way, is Judge Kozinski. As you might gather from his picture, he's a rather colorful guy with a lot of various colorful interactions with lawyers and so on, which we won't get into here, but he's also very well known in the internet law community. He's also, kind of like Judge Posner, a colorful writer. And so Kozinski has a couple of great quotes. Minds have wandered since the beginning of time. The computer gives employees new ways to procrastinate by G-chatting, playing games, shopping, and so on. He notes that, and correctly notes, such activities are routinely prohibited by many computer use policies. He says the effect of this broad construction of the CFA has on workplace conduct pales in comparison to a whole variety of other things that we do every day, the iPad, the Kindle, the Nook, the Xbox. Now, when this case was being litigated, a number of groups, like the Electronic Freedom Foundation, a variety of other groups like that, were very concerned about this case, and they felt like it would give the government an opening to prosecute all sorts of crazy terms of use violations against individuals on behalf of big commercial information entities like Microsoft and so on. And Judge Kozinski really bought that whole line of argument. He says, kind of humorously, right, consider the numerous dating websites whose terms of use prohibit inaccurate or misleading information. Or eBay or Craigslist, where you can't post, it's a violation of terms of use to post an item in an inappropriate category. Now, he says this, and think about this in light of later developments in the Aaron Swartz case, right, that we've looked at. The government assures us that whatever the scope of the CFAA, it won't prosecute minor violations. But we shouldn't have to live at the mercy of our local prosecutor. Now, I don't know whether Kozinski would have thought Swartz's conduct was minor or not, but his point here is to say that relying on prosecutorial discretion isn't really good enough. What we need, he says, is a very clear understanding of the statute that doesn't allow the statute to even conceivably be applied to these much broader areas of conduct. So as you see, there's a dissent in the case, and the dissent kind of looks at the statute a little more directly, reads the language and says, look, this language covers this kind of conduct. And it really just dismisses, with a bit of a wave of the hand, the hypotheticals that Kozinski comes up with and says, you know, these things are not really realistic. It's highly unlikely that anything like this would ever be prosecuted. If anything like that was prosecuted, we could interpret the statute to deal with those sorts of, you know, overly ambitious prosecutions. But the dissent says that's not the case we have before us. We have a very different case.